Bill Key, Joe.
Just a quick question. I'm still confused. When you say it's constitutionally protected, it's not specifically in the Constitution, but the Supreme Court has ruled that women have a right to abortion. Is that what you're saying? Is the Supreme Court's ruling then part of the... why is this then a constitutional right? It's not really a constitutional right, or does it somehow, does the Supreme Court basically add to the Constitution?
Yeah.
Because this is a question that we come up with a lot on the street when people mention. And the other part of this then is, what authority does the Supreme Court really have in this issue? Because that's another question we come up. Because if it's not a constitutional right, then we need to say it's not. It's a Supreme Court opinion, just like Dred Scott was a Supreme Court opinion, which is still on the books. So I have a hard time understanding exactly what authority the Supreme Court has in this issue, and whether it's proper to say that this is a constitutionally protected right, or simply an opinion of the Supreme Court that doesn't necessarily have the same weight as a constitutional right.
Can I just clarify? I'm not saying at all this is a constitutionally protected right. I'm saying that's what they say. So,
well, and it comes down to sort of a judicial philosophy, like you said. It's first week of law school. You learn that in the cases, I think it's Marbury, right? Marbury versus Madison, that the first Supreme Court said that when the Supreme Court interprets a constitution, that becomes the Constitution. That is the law of the land. And that's something that the courts are based on. It leads to a question that Keith is going to ask a little later about what's positive law versus natural law. And can you have positive law that contradicts the natural law? That's almost a larger sort of judicial philosophy debate. But that is the status quo. If you were to ask a panel of the Supreme Court whether their rulings are part of the Constitution, they would say yes. The interpretation of the Constitution is the Constitution.
Then we have a Constitution that still has Dred Scott on the books, but then we have an amendment which basically has gotten rid of that. And so
yeah.
How does that work?
Well, an amendment to the Constitution, basically it nullified Dred Scott. It's still in the books, and actually Dred Scott is still cited today, believe it or not. I can't imagine a judge who would want to cite to it, but they do. They cite to it for substantive due process, some of the technical aspects of it, obviously not for the holding that an African American is property, not a person, but they still cite to it. It wasn't overturned. It was just voided with regards to that central holding.
So from a very early decision, then basically whatever the Supreme Court opines becomes the same weight as the Constitution.
That's like Plessy versus Ferguson, and then Brown versus Board of Ed. I mean, it's stare decisis, so the most recent decision is the one that holds.
And stare decisis, etc., that still has the same weight. I mean, that's a constitutional right then.
It does and it doesn't.
I'm sorry.
I mean, for practical purposes, for implementation of laws, for judicial review when a law is passed and the court has to review it, that is a constitution. That is what they look at, is their own decisions. And they have increased their power as the years have gone by. And that's something that's seriously wrong with our system, but that's the way it works. It would be foolish of us as lawyers to say that that's not the way it works, because that is the way it works.
Yeah, and it's like you're totally not being culturally relevant at all if you're just going to stick your head in the sand and say, well, that's not right, and the Supreme Court shouldn't even have judicial review. And Marbury versus Madison, back in the early 1800s was just wrong, and so we're not going to take any strategy that appeals to that. It's like, that's absolutely foolish. This is what we're stuck with. We have to work with this.
Yeah.
And
that brings up the question of, by asserting that a state has the right to declare that all human beings are persons, are you saying a state has the right to declare that human beings are not persons? And we're not. We have to sort of operate within the constraints of our legal framework, the way that we operate within the law. And so, the courts will review this, and I think it kind of gets back to the question the comment that Keith made, that is, really personhood is bigger than a legal approach, than our legal opinion here. It's so fundamental that it changes the whole way that we view the law. And really, when the law acknowledges that its own citizens aren't persons, then it shakes its own legitimacy. And so what we're working for here is so much bigger than, what the latest precedent of the Supreme Court is. It reaches back to Marbury versus Madison of the legitimacy of the court, of the legitimacy of the law itself. And so the fact that we are guided by fundamental truths, I think, is the safeguard that we can be assured that we're doing the right thing. It's not that, we think we have a sort of a loophole in the law because Justice Blackmun said that if the personhood of the unborn is established, then the right to abortion collapses. That's true. But really, it's much bigger than that. We're working for a fundamental truth. And I'll comment on that also, that the way that these amendments work, when I work with Dr. Thompson, for example, in Missouri, the way we word these amendments is important, and where we place them. We place them in the Bill of Rights of a state constitution, which is usually where these natural rights, these inalienable rights are found. And so these things are bigger than an abortion ban or a statute. These are sort of foundational principles, and that's why we put them in the Bill of Rights. And that's why also having an amendment that's simple is correct. Some people say, well, how can a 14-word amendment be legal? It's just too vague. And my response to that is, well, let's look at the Bill of Rights of our Constitution, the things that we cherish the most, the right to the Second Amendment, the First Amendment, freedom of speech. Do we take 10 pages to explain freedom of speech, or do we set a foundational principle? And so that's what personhood is about setting this foundational principle. And in doing that, we get to educate people in a level that they understand. We're not trying to explain, the health care bill with 3,000 pages to people on the street. We're saying, is a human being a person, or are they property? And if they're a person, shouldn't we protect them equally? And that's something that everyone grasps. In Colorado, and Cal has seen this around the country, when you circulate these petitions, you go to people, and you're going to people that are highly educated. You're going to people that dropped out of school. But everyone gets that. Everyone gets that because it's so fundamental. And so we had people, obviously people who are obviously gangsters with tattoos and piercings everywhere. And we presented these petitions to them, and they'd look at it, and they're like, what's this about? We're like, well, read it. And it's 14 words long, and they read it, and they're like, oh, so, you shouldn't kill babies? And we're like, yeah. And so people get it. And that's because, these truths are natural. The definition of natural law is these things that God puts in our hearts. And so everyone gets it. And we want to return that to our positive law, to the law that we make as citizens.
Dr. Thompson.
Thank you for that last comment. Because that's where I was going. My best friend prompted me to come up here. And this effort honors and glorifies the good Lord. And that alone is all we need. And he will produce fruit because we are true to that. Fruit will come because this personhood effort honors him.
And we're not called to win the battle. I mean, to me, this just reminds me, the naysayers are like the 10 spies whose names you never remember. Who are like, we would have been better off, if we were in Egypt. Like the status quo here with the killing of babies is okay, and like we don't want to make it worse. Like, how could it be worse? What are you talking about? And I want to have the same spirit of David, and I want to have the same spirit of Caleb and Joshua, and say God is on our side, and we're going to do what's right. And it shouldn't matter ultimately what the outcome, but going to the issue of time and money, the waste of time and money, I think that this is the most efficient pro-life effort ever. Think about all of the time and money that has been spent since Roe v. Wade. And what have they achieved? I mean, yeah, every life matters, but come on, what have they really achieved? You want to talk about a waste of time and money. This is the most efficient effort, and you're not talking about big organizations, where you're funding all kinds of positions and all kinds of offices. I mean, this is a lean effort, and you're getting a lot for your money, and you're getting a lot of volunteers recruited who are coming out of the woodwork who were not mobilized before. And so we're getting a lot out of it. I think this is the greatest effort, ever in the pro-life movement, and the most efficient one.
Amen. So I'm going to skip a few of these. You guys have a list here, and we have a few cheat questions, but I'm going to skip a few of them. I guess the question would be, does the Personhood Amendment, when passed, ultimately rely on the courts and legislatures, once it's passed, to implement such an amendment?
Okay, well, Ed Rivet from Right to Life of Michigan, he's their lobbyist. When he thought that we might have had enough signatures to turn in, Cal, you remember this? The day before, they had opposed us the whole way. The day before we were to turn signatures in, he released a memorandum of law on the status of abortion in Michigan when Roe falls. And it was the best argument I've ever seen for why we need to do this now. Because he painted a picture of pandemonium. That basically he said, okay, yeah, Michigan has a law that was never repealed, and an abortion law that was never repealed, and it's not the greatest law. And he said in order for that law to be implemented, he said that the Attorney General would have to issue a proclamation that he's now going to begin enforcing that law. Or if the Attorney General didn't do it, he said that prosecutors in different counties could do it, and maybe some would and maybe some wouldn't. And then there would be challenges to those, prosecutors like now implementing it. And then there would be petition drives being brought, some making it legal with different standards and trimester schemes, and others making it illegal with different exceptions and standards. And then there would be legislation that would be brought in the different houses with all of those different standards and legal, illegal, and there would be mass confusion over which one am I signing and what is this for. And I mean, it was like the perfect argument for why we should do something now. We were having a discussion last night about what could happen, and I agree that there's no reason why prosecutors and detectives couldn't begin investigating abortions as homicides under our homicide statutes. But I think that it would be good to have laws passed that would be specific to know the expectation that prosecutors and detectives need to begin addressing this issue. And so there could be laws passed, but I agree that it wouldn't be necessary to have them passed.